Let's see. Frederick, Edmund.
He's got something, I think he said in ward, and he also was running downstairs real quick, but he's here and about.
Okay, you have something, Mr. Richardson here says. Continue the Google Mouse. And then Ms. Wanji has Mr. Timothy. On the record in the matter of the people of the state of Michigan versus Jalen Jason Timothy, file number 22-03410, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people. Melanie Edmund, you going to Timothy, who's by my side.
How are you, Mr. Timothy?
No, very good.
Okay, today was the date that was scheduled for a probable cause conference. Matter is scheduled for preliminary examination, May 3rd at 9:30. Are we continuing to examine this?
You know, we like to, my client would like to waive his timeline to have the preliminary exam within the 21 days of the arraignment. The reason is that he needs more discovery from the bank. He has some paperwork that he needs to show me so that we can accept or we can fight the case. Without those people, I don't know that I'm able to give him any meaningful advice regarding the case.
Oh, you know how long it will take for you to get that information?
So Judge, I can't get anything through PDF or email, so they said that's gonna take up to 21 to 30 days, business days for them to send that mail out. They cannot send it no other way. They have to send it through mail.
Okay, sounds good. So you understand that you have the right in this matter to have a preliminary examination within 21 days of the date that you're arraigned. And due to your need to get additional discovery to allow your attorney to review to help assist in formulating your defense, are you willing to waive the timeline so we can reset this at least 30 days out? Yes, ma'am.
Excuse me.
Yes. Oh, yeah, excuse me.
Sorry. Thank you.
June 28th, at what time?
9:30.
9:30.
Thank you.
No problem. Do you have any questions for the court today, Mr. Timothy?
Yes, ma'am. Would you like for me to provide documents as well too?
You provide them to your attorney.
Okay, my bad. I'm sorry.
No problem. Any additional matters for the record?
Nothing for the people.
Nothing for the defense.
Thank you. We'll get you your notice to appear and then you'll be all set, okay?
Yes, ma'am.
One second, I can bring it. I'll bring it back to you. Probably that fan that's making you sleep.
I'm sorry. You mind if I step out real quick?
No problem.
All right, 1 second.
Ms. Donnelly, are you ready with Mr. Day?
Yes, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Joshua Scott Day, file number is 24-01035, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
An Assistant Public Defender, Sarah Donnelly, on behalf of the defendant, Joshua Day, who is appearing separately from the Ingham County Jail.
How are you, Mr. Day?
Yes, good morning.
Okay, good morning. Today's the date that's scheduled for a probable cause conference. This matter is scheduled for preliminary examination, May 3rd at 8:30 in the morning. Are we continuing to examine?
It's my understanding that Mr. Day intended to waive up to the circuit court today. And if that's still what he intends to do, the people also unconditionally waive the right to a preliminary examination and ask the case be gone over his jury.
Ms. Donovan.
That is correct, Your Honor. We intend to negotiate with the felonies in circuit court. So he is waiving his preliminary exam for on this case, and hopefully he has the other preliminary exam on the other case where it was adjourned to next week, and he'll waive that as well.
He has another matter, what are you saying?
Because he has a felony matter we had the PCC for, I believe, last week. And then, but it was adjourned out to allow this case to work its way up.
So you would like to waive both exams?
Yes, Your Honor.
We need that file then. Awesome record. Okay, I'm back on the record and I now have people of the state of Michigan, file number 24-00368 versus Joshua Day. And in both matters, Mr. Day, you are being charged with felonies. You have the right to proceed to a preliminary examination. You have the right at your examination to require the prosecution to put forth evidence that would establish that they have sufficient probable cause that a crime was committed and then sufficient probable cause to charge you with the crime. Do you understand your right to exam so far?
Yes.
Are you willing to unconditionally waive your preliminary examination to have these matters bound over to the circuit court?
Yes, ma'am, I am.
Okay, you understand that you can't change your mind once these matters are bound over and that waiver is being made freely and voluntarily, correct?
Yes, ma'am.
Okay. Bind over on each file is going to be May 8th, 2024, but you do not need to appear in circuit court on that date. That's the date that the circuit court will get the files from the district court, okay?
Okay.
Unless your attorney files motions in each of these files for you to be rearranged at circuit court, you will not be arraigned at the circuit court level. And your next court date will be a pre-trial at circuit court, and Ms. Donnelly will be made aware of that, okay?
Yes, ma'am, thank you.
No problem. Do you have any questions for the court?
I do not, thanks.
Okay, file number ending in 364, bond was set at 15,000, 10%. There is an order for random testing one time a week. File number ending in 135, bond was set at 5,000, 10%. There is also a order for random testing weekly, 2 times a month. Do you have any questions about your bond conditions?
No, I do not.
Bond will continue in both matters. Any additional matters for the record?
Nothing for the people.
And nothing for defense. Thank you, Your Honor.
Thank you, you're all set.
Thank you. Oh, good ears.
So I don't think I could have do sure, but isn't supposed to, so I'm just gonna talk to that girl over.
Oh, I got you.
Okay, so these are starters. Yeah. This is here. Feigelson on Selenas. Morning, Mr. Feigelson.
Good morning.
You're here for Selenas. I don't know if that's the individual that has on the green sweatshirt that has not started his audio.
I am not sure, Your Honor.
Okay. Can you hear me, sir? You have to unmute. What's your
Yes,
name?
can you hear me?
What's your name?
Roberto, Ava Salinas.
Okay. Mr. Feigelson, that's your client. I'm assuming you've not spoken with him or you
I
just never
have
seen him?
spoken. I have spoken with him. I just haven't seen him personally, Your Honor.
Oh, okay. Are you ready to go on the record?
I believe we are, Your Honor.
On the rec, well, we need the prosecutor.
I believe we do. That's correct.
On the record in the matter of the people of the state of Michigan versus Roberto Selenas, file number 24-01106, appearance please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Roberto Selenas, who's present by way of video conferencing this morning, Your Honor.
Okay, and today was the date that was scheduled for a probable cause conference. This matter is scheduled for preliminary examination next week, May 3rd at 9 o'clock in the morning. Are we continuing to examine?
We are, Your Honor.
Okay, any preliminary matters that we, or any other matters we should address while we're here today?
Nothing for the people.
Your Honor, nothing on behalf of Mr. Selenas.
Okay, we'll see Mr. Selenas and you in person next week at the court, 9 o'clock in the morning. I don't see any issues with bond. That will continue.
Very well. Thank you, Your Honor.
Thank you. You're all set. You're free to go, Mr. Selenas.
All right, thank you. What do you got?
Mr. Selenas, you still there?
Yeah, I'm trying to
Can you
turn
hang
this
tight?
off.
Wait a minute, stay there very quickly, don't leave. I have to address something first. Could someone call Mr. Feigelson? You can turn your camera back on. Okay, we're just waiting for your attorney to log back in. Mr. Feigelson?
Yes, Your Honor. Good morning.
Thank you.
Again.
Thank you for promptly returning. As soon as I released your client, I got notification of a bond violation. Back on the record in the matter of the people of the state of Michigan versus Roberto Selenas, file number 24-01106. Appearance, please.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Selenas.
Okay, Mr. Selenas.
Oh, sorry.
I just received a complaint of a conditional release violation. It alleges that on or about the 23rd of April, 2024, that you violated the terms of your release from custody by making contact either directly or indirectly with the alleged victim in this matter. I do have a police report here, and it indicates that there was a report made that the victim contacted the police regarding messages on Facebook Messenger and calls allegedly being received from you to her, and that there were attempts for 2 days to make contact with her. She stated she's blocked the number, and she's provided photos of the messages and screenshots to law enforcement. And so you have the right to have a contested hearing on the allegation that you violated your bond condition. A violation of a bond condition is punishable by 93 days in jail and or $7,500 in fines. Do you understand that?
Yes,
Okay. And so, Mr. Feigelson, I'm assuming he wants to enter a plea of not guilty and set it for a hearing.
That's correct, Your Honor.
So we will enter a plea of not guilty at this time. This matter will be set for a hearing on the bond violation, the same date and time as your preliminary examination. That's going to be May 3rd at 9 o'clock in the morning. We're going to review your bond conditions with you again, just in case any of them were unclear. You have a 10,000 cash surety bond. If your bond is violated, that bond could be revoked. Do you understand that?
yes, Your Honor.
You could also be sitting in jail pending the ultimate disposition of this case, even if it has to go all the way through to a trial in the circuit court. Do you understand that?
Yes, Your Honor.
You have a bond with conditions, including GPS tether, victim notification, if possible. You're not to be within 2,000 feet of wherever the victim is. You're not to have contact directly or indirectly with the victim. Do you know what indirect communication means?
Yes, Your Honor.
Says you're not to assault, harass, intimidate, beat, molest, wound, or threaten Sarah Tropfatter, or Trofatter, I believe is how her name is pronounced. Again, you're not to cause anyone else to do any of those things on your behalf. You can't call her, you can't text her, you can't message her, you can't mail her a letter. You can't ask anyone else to do that for her, on your behalf. Do you understand that?
Yes, Your Honor.
Is there any questions that you have about your bond conditions?
No, Your Honor.
Okay, so we'll address the bond condition at hearing, or the bond violation at hearing next week, as well as the preliminary examination for one count of home invasion, first degree, aggravated stalking, and domestic violence. Any additional matters for the record?
Nothing from the people.
Your Honor, can we get a copy of the bond violation? Because I have not seen that yet.
She'll send it through email and then I'll forward it.
Yeah, the clerk's office will send it via email. We just received it. Look, as you was walking out, she walked in here and handed it to me.
Very well. I appreciate that. Thank you, Your Honor. May I have a break room quickly with Mr. Selenas, Your Honor?
No problem.
Thank you, Your Honor.
Okay, let's see. I need Mr. Etheridge here. Because he has two people here on my Zoom.
Thank you.
I can't hear you. I cannot.
We're not talking to you.
What? Oh, yeah. Well, it should be nice. I hope it is.
Okay, ma'am, what's your name?
Culverson.
Okay. Mr. Goodrich is on one, and Mr. Lee, you ready on Ms. Culverson?
Yes.
Okay. On the record in the matters of the people of the state of Michigan versus Takesha Culverson, I have file numbers 23-01451 and 23-02087. Appearances for the record.
The public defender, John Lee, attorney on behalf of the
And Attorney Luke Goodrich from the Public Defender's Office, representing Ms. Culverson in file 23-2087 FY. And I will be deferring my allocution to Mr. Lee.
Very good. Okay, so today was the date set for sentencing. There's a lot of activity going on outside this wall. Set for sentencing on both files. Let's see. And it looks like the pre-sentence reports that I have were from, well, at least one is dated for September 6th. They're both dated September 6th, 2023. Ms. Culverson, that is, had failed to appear for either sentencing. I had to issue a remand to get her here. Any need to make corrections, updates, or deletions?
corrections. Except for the credit for her time served, Your Honor, which I believe is at this point 43 days.
Maybe she picked up on this warrant. It was like April 5th.
Yeah, that shows that she was.
Okay, the timing on both are not the same. Prior to her being picked up in April, on file number ending in 2087, she had 20 days. And then the other file, 28 days. You can make allocution.
Thank you, Your Honor. Ms. Culverson comes before the court today in a very different state of mind than the court has probably seen her before. The reason she missed her last sentencing date is she was struggling with mental illness, had a very serious mental illness issue. She was self-medicating, as is not unusual for people who are suffering from mental illness. So after she got picked up and brought in, she was able to re-engage with CMH. CMH started her on a monthly program whereby she shows up and gets a shot once a month that really helps control the symptoms of her schizophrenia. So where the PO, or the probation officer rather, notes that, she may have lacked cognitive understanding or may have had strange behaviors, I would mirror those observations early on in my interactions with Ms. Culverson, but she presents very differently, and both Mr. Goodrich and I noticed in our last conversation with her, the medication does really seem to be helping. Her plans, if she is able to be put on probation, Your Honor, would be to continue treatment with CMH, continue to get her monthly shots. We would ask the court to consider outpatient substance abuse support for her to help continue her on her path of sobriety. She's going to be applying for Social Security disability income and looking basically to establish her life as a person who is now.
This is obviously what's going on with court.
Can you mute your device, please? We're in the middle of court.
So she's looking to re-engage, Your Honor, into the community and society as a person who is now being treated for her mental health. And we expect that she will be much more functional as long as she is able to do that. So we're asking the court to consider a term of probation for Ms. Culverson.
That's interesting. That's not the recommendation.
The recommendation from the probation is jail. They don't think she's a good candidate for probation because of the behaviors they observed when they first encountered her. And as I said, we noticed it too, but she was diagnosed with schizophrenia. And now that she's taking her monthly shots, she presents very difficult.
Your client want to make a statement.
Ms. Culverson, do you wish to address the court?
Yes. Hi, Your Honor. I apologize. First off, foremost, about not, coming to court. I apologize for the inconvenience. Like my lawyer was saying, that is true. I plan to make I've been becoming more responsible and getting better in coping because it was a new era with the disease. It was kind of new at the same time. Was just figuring it out, and coping was hard to cope with, but I'm way better. I'm actually improving, and I'm ready to come back I'm at my normal senses, and I'm stronger mentally and physically, and even with the addiction, I'm stronger. I am off crack cocaine. Should not be no problems. If I'm going to be observed on probation, I'm pretty sure if I get another chance that I will be able to prove to you that I will be able to make it once the warrant is clear. All my warrants should be clear. If I was to get out today, I would be going straight to the shelter, but I will be working with CMH for rehabilitation, rehab. I plan on going to ride sober living all the way and put the income in the whole situation in housing.
Thank you. I'm glad to see that you are clearly operating in a better headspace, and that you seem to have some plan of action as to how you could move forward if given an opportunity to be on probation. I have here, again, a malicious destruction of personal property. And then I think the other was an attempted police officer assault, resisting, obstructing. The probation department didn't think you would be a good candidate for probation, even though I reviewed your prior criminal history. You've done probation in the past. I don't see, maybe you've at least successfully completed probation previously, at least on two of your previous convictions. One of them, it looks like you were on probation for 18 months and you were successful in completing. So you're capable of doing what you need to do. What we want you to do is not just be capable and follow through, but that it makes some kind of meaningful change. We don't need you to just be committing actions, getting stabilized in your meds and in your life, and following through with probation just to re-engage with the criminal justice system. We don't want this to be a continued cycle for you for the duration of your lifetime. And at this point, you're developing quite a lengthy criminal history. And one of the issues or concerns that the probation officer had when you were interviewed for the pre-sentence report was you didn't appear to want to discuss your reasons for unemployment.
I was. I didn't really have the answer then, but like I told her when she told me, was very apologetic, and I was willing to work it out. And I don't know if she knew.
If you're placed on a term of probation, one of the things you're going to be required to do is get employment. Do you understand that?
I'm doing. I do construction. My people. I do. I've already I do a lot of felon work anyway. And my husband, he owns. Before I got arrested, I had a conversation with him and his brother. They do stuff of people that they have a construction site, and they was paying me to do jobs because they understand. So I usually work with them, and he will understand. He pays me to do jobs. He wants me to be done.
I recognize part of what you're saying. It was a little difficult to grasp because of I think you're speaking a little low. I need you to sit up so that the mic can pick up your audio. The other thing is it was going in and out. It sounds like you said your husband has a company.
Yes, and his family and his brother, they help people like me. They have construction where you do well, that's what I'm trying to say. I do construction. I do demolition. I can do yard work. He just taught me how to do pick up trees and load it into the trucks and stuff. And
I don't care what kind of work you're doing. It just needs to be a job that you are employed by, and you can provide evidence that you are employed. Under the table will not qualify. You need to have a real job that the government can verify. You recognize that?
I understand. I've been through it before. Yeah, actually, it shouldn't be no problems with me in Lansing. It's so many jobs that I've been offered, but I just didn't do it. But I understand. I will, and I will turn that into.
Yeah, if you're on probation, one of the things that the goal is that you become stabilized as a member of this society, in this community. And so one of the main things, once you have gotten a grasp, and it appears you have, of your mental health and your substance abuse issues, is if you want to be successful, you got to be doing something meaningful,
yes,
like working or going to school. If you told me, you know what, Your Honor, I am going to be enrolled in school right now because I really want to further my education, I wouldn't require you to work. But you're not going to just sit around while all the other fully functioning adults are doing something meaningful and think that that's going to fare well for you while you're on probation. You're going to be required to do something that benefits you in the long term. I'm going to give you a chance at probation. Probation will be set at 12 months probation.
Thank you. I appreciate you for the chance. I will not let you down because I know I need to come. I was thinking about that today. I'm tired of those stuff. I'm ready to clear my record. I'm just so want to put this behind me. And I know, but it's better to move forward than not move at all.
You talking now. Now you're talking. Okay. I want you to remember that. I'm going to write that in your file so that, and hopefully I never have to use it, because if I have a probation violation from you, you won't be moving at all. Do you understand that? You're going to move forward, or you're not going to be moving at all. You'll be sitting in jail. Those are your options. 12 months probation. While on probation, you will be assessed and get treatment for both mental health and substance abuse. Ordering intensive outpatient.
That's what it sounds like. Thank you so much for that. I'm just glad that I caught on.
I'm not finished. I'm not finished yet. We just got started.
You just fine.
So you'll be assessed and you'll undergo treatment as recommended once we receive that assessment, as it relates to any mental health or substance abuse that is not being properly addressed. You're going to get a job and you're going to provide evidence of that job, okay?
Yes, ma'am.
How far did you go in school? How far did you go in school, ma'am?
11th grade.
I'll give you an option. You'll either get enrolled to finish your high school diploma, or you'll obtain a full-time employment. Either way, you're providing verification of that to your probation officer, okay?
Okay.
While on probation, you're not to be inside of any bars or nightclubs. You're not to use, purchase, or possess alcohol, marijuana, or any other controlled substance unless a doctor prescribes it to you. Do you understand that? Do you understand that?
Yes.
Okay, you're going to be required to submit to random preliminary breath testing and urinalysis testing. You have to pay the fee for that. So I don't want to hear that you're not testing because you don't have the money for it, because you all requested probation, okay? Another reason why you got to be employed. Do you have any questions so far? I can't hear a response.
Oh, no, I do not.
Okay, you're not to engage in any assaultive or threatening behavior. There's a $30 per month oversight fee that you're responsible for while on probation.
Okay,
There's 70, so for 12 months of probation, that's gonna be $360. There's a $75 crime victim rights fee that you must pay plus a $50 state minimum cost. The court's going to waive discretionary fines and costs at this time due to your indigency status.
okay, thank you. I'm still listening.
Okay, very good. I don't see where there was any restitution on the malicious destruction of property. That's correct?
Yeah, that's correct, Your Honor.
Okay. As to that file, credit you time served.
Thank you. Okay, I have a question, Your Honor. I'm so sorry. This is it. Am I getting out today?
Well, let's cross a couple other bridges before we get there. Okay. You have 48 days on that file served. Credit you 48 days. We'll waive fines and costs. So again, you're on probation on the other file, okay? That's file number ending in 2087, okay?
Thank you.
Okay. Then there's an advice of rights as to probation. It says you've been sentenced to a term of probation in the 54A District Court, except for the charges of domestic violence, criminal sex crime, stalking offenses, or offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you completed half of the original term ordered by the judge. Your probation officer may, but is not required to. They can file a notice with the judge to request your early discharge. If they do that, they would provide a copy of that to the prosecuting attorney. The prosecuting attorney will have 14 days from receipt of that notice to make any objections in writing to your early discharge. You, ma'am, can make your own request for early discharge after you complete 6 months of probation, provided that you don't violate within 3 months prior to that, and you have completed all of the required programming that I've ordered you to do. Do you understand that?
Yes, thank you so much.
If I set it for a hearing to request early discharge from probation, you do have the right to hire an attorney to represent you. You do not have the right to have court-appointed counsel for that purpose, okay?
Okay.
Do you have any questions about your right to early discharge?
No, I do not. I'll do it. I'll figure that one out.
Okay, as to your question, you will be required to meet with probation to go over my order. You should be released because this is now being disposed of and you're going to be on a term of probation. You, ma'am, need to report to probation in person to check in with them by Monday, 9 o'clock in the morning.
And I will be there with no problem, thank God.
If you do not report by Monday, I'm going to issue a warrant for you for violating my order, okay?
Okay, so I can go today if not go by 9,
No, you're gonna go by Monday. I don't want you to go today.
Okay.
Because we need you to come, you're gonna be discharged, you're gonna go Monday, you're gonna check in. And the reason why we have to do that is because you're telling me you're gonna be released to go to a shelter. I don't really know where you're gonna be staying.
Okay, so that means go to shelter. That's what I'm there. I'm there.
Well, that's where you told me. You told me you're gonna go to the shelter. Even though earlier this month you told the magistrate that you were gonna be at 735 Chicago. I'm assuming that's not a good address for you though, okay?
Well, for mail, but.
Okay, that's a good address for mail. And then what, are you gonna be at the shelter? You gave an address of 2216 South Cedar?
Yes, if I could get, okay. if I just need early release, I mean, time wise, and yeah, you gotta be there, you have to be there before 5. Your Honor.
Okay, so again, you're gonna be released as soon as they can process this paperwork. You should be released today, and then you're gonna check in person at the court, at the probation department, no later than 9 o'clock on Monday.
Okay, yes, ma'am, I'll be there.
Do you have any questions for the court?
Oh, so you're gonna send, oh yeah, and also you can send that to the shelter, all my mail, right? Until I change the address from when I go to Rice.
Okay, sounds good, but you'll provide all that information on Monday when you check in.
Yeah, okay, that's right. Thank you.
Any additional
Okay.
matters for the record?
Nothing further, Your Honor.
You're all set, thank you.
Thank you, lawyer.
Thank you.
That was.
Just one. One of them just did, so I'll put them in the break.
Can you see me? Yeah. P1.
Okay, let's go. We don't know these overs, right? Is Leo Bayard here?
Yes, Your Honor, right.
Okay, on the record in the matter of the people of the state of Michigan versus Leo Bayard, file number 18-05724, council appearance.
This is the prosecutor, Paige Petrosky, on behalf of the people.
Thank you, Your Honor. Good morning, Attorney Barnett Levine on behalf of Leo Baird, who's present, standing on my right.
How are you, Mr. Bayard?
Very good, Your Honor.
How are you, Mr.
Of course,
Levine?
Much better. Doing much better now. Thank you.
Okay, today's the date set for sentencing. I do have a pre-sentence report and recommendation. It was dated prepared on April 11, 2024. Did you get a copy of that?
We have it.
Okay, any need to make corrections, updates, or deletions?
None.
None from people.
Okay, you can adjust the court.
Thank you, Your Honor. I appreciate it. So it's not every day that there's status, even in the PSI report, of an effective sustained remission for things that include heroin, cocaine, marijuana, alcohol, methamphetamines. So there's a list of things that go on, but my client also has the humble understanding that sobriety is an ongoing care. So with that in mind, there's no objection to any of the recommendations in the PSI report. And indeed, that informs him voluntarily taking the affirmative step to come into court to addressing this thing. There was a warrant that was outstanding at the time that he was struggling with the same things from which he's now free from, and an ongoing free. So, there's still work to be done on that. As far as the part of the PSI report that talks about the underlying issues that informs my client's history as to when he started doing them, it doesn't really expand on that. But after a personal exchange with my client, he assured me that he treated those underlying things, those things that misled him or misused for him to do other things that he also shouldn't have been doing. So those were other points of concerns that are also treated. With that in mind, he has no objection to the to all the prototypical requirements, victim impact panel, and the like that come with the charge to it.
Oh, very good. And does your client want to make a statement at all?
Yeah, I take full accountability of my previous actions. There's a lot that I've worked on as far as my personal life, my behavior. That's not to say that I don't have bad days now, but I have better means as far as coping with them. Right now, my main goal is to get this handled. I have a lovely 2-month-old daughter right outside the courtroom right now that I'm very excited to be able to, go out in public, not be afraid of getting picked up on a warrant or anything like that. Spend some time with them.
Our criminal history, I don't see anything pending since this incident, which occurred quite some time ago.
Full transparency, Your Honor, I've been in Florida with the bringing of my daughter. I wanted to be around my family and my wife's family. There was no legal trouble in Florida either. Coming up here, turning myself in was just a necessity for me to be able to have the support of my family and my wife's family.
I'm glad that you're taking corrective action. And you're going to be returning to Florida?
No, Your Honor.
Okay, again, due to the actions that you've already taken since the time of this alleged incident to help address your underlying issues and the length of time since that with no other interaction with the court. Just to be clear, if there was something lingering even in Florida, it would have been noted when they provided me your criminal history. And there's been nothing since this incident, which is positive for you, and hopefully you'll continue on that path I think having support of your family is probably beneficial to your long-term life and recovery. So what we'll do here is adopt the recommendation, which is for you to again re-engage in a not impact panel, victim impact panel, and provide evidence of that. Have you done that already?
No, Your Honor.
I'll give you 90 days to do that. And then they are requesting that you participate in a 12-step program. Are you already engaged in ongoing support?
I was very active in the AA community when I lived in Florida. Since moving up here, I've lost contact. That's something that me and the probation officer that did the PSI touched base on. I'm still in contact with sober friends in Florida. I haven't established a sober community that I'm active within in Michigan. That's not to imply I'm around people that are currently using. Just make that distinction. I just haven't been to AA meetings or NA meetings since I moved back up here.
Sounds good. So the court is going to adopt that recommendation, order that you attend 30 12-step meetings and obtain a sponsor locally, okay?
Yes, Your Honor.
We're not going to put you on any supervision of the court. We just requiring that you provide verification of those things to be compliant with the court order, okay?
Yes, Your Honor.
As to fines and costs, there is a $75 crime victim rights fee that must be assessed to the $50 state minimum cost. That must be assessed. Prosecutor recovery fee of $120. That will be assessed. I don't see any OWI cost recovery. Is this Michigan State Police? Ms. Petrowski, do you know if this was Lansing Police or?
I don't believe that we have any OWI cost recovery for MSP in this case.
Looks like it's a Lansing Police Department case, and they always have OWI cost recovery.
Yeah, this is Lansing.
But they didn't submit OWI cost recovery. Okay.
No, I did not.
So. $75 plus $50 plus $120. And the court's going to assess the fine of $300. It's $545 you to make monthly payments, or that, or you can pay it in full. How do you want to proceed?
What I plan on doing is doing a big chunk up front next week and move forward with monthly payments.
Okay, how much do you plan to pay next week?
How much did you say the total was?
$545.
I can do $250 next week.
Next week, which day?
Wednesday.
Next week, Wednesday, it looks like it's the first of the month. We'll put May 1st, and how much you gonna pay by June 1st?
I would like to do $150 a month after the $250 if possible, or $125 rather. My biggest hurdle right now is just chasing people around, get my invoices paid.
Understandable. If you need to adjust that payment plan, you'll just come into the court. You'll let them know that you need an adjustment on the payment plan, and they'll bring the file to me, okay?
Yes, Your Honor.
So I'll note here, for the time being, you're gonna pay $250 by May 1st. You'll pay $125 per month on or about the first of the month until paid in full. The first of the month of June is a Saturday, so you'll pay by the 3rd, okay?
Yes, Your Honor.
Do you have any questions for the court?
No, Your Honor.
Any additional matters for the record, counsel?
No, thank you very much.
Thank you. Good luck to you, sir.
Thank you.
And on the record, in the matter of the people Office of the State of Michigan versus Olivia Riley. File number is 24-00196. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people. Aaron Robinson, Assistant Public Defender for Ms. Riley.
How are you, Ms. Riley? I'm well, thank you. Okay, today's the date set for sentencing. I do have a pre-sentence report that was dated prepared April 17th. Council, did you get a copy of that?
I did, Your Honor, and I did, Your Honor.
Do we need to make corrections, updates, or deletions?
Not at this time, no.
Make allocation.
Yes, Your Honor. We would be asking the court to follow the recommendation put forward in the pre-sentence investigation report. I believe this is an isolated incident as probation discussed in the PSI. Ms. Riley has expressed great remorse for what happened. She does not want this to be a pattern of behavior. I believe that the 50 hours of community service work and the 4 months of non-reporting probation would be appropriate for her with the HYTA status. She is currently working. She does work at the Menards Garden Center, as well as attend college part-time, otherwise doing very well in life. She also has her mother here for support. Did we ask the court to follow the recommendation?
Would you might want to make a statement?
She does not at this time.
The concern that I have is, although this is the first conviction, it's not an isolated incident as it relates to how many times she's been charged.
Yes, Your Honor, it was a first diversion case that then got reissued.
You mean this case?
Correct.
She's been charged with domestic violence twice. That's my concern. And that's not related to these. Charged twice last year. That's a concern. I think that the term of probation on HYTA is appropriate, but there's not, obviously needs to be some programming to address how you're making decisions when you're in situations that could provoke you. You're in school full time? How many classes are you taking? You're taking 2 for the summer? I can't hear head nods on the record.
Oh, yes.
Okay, and so what's your plans for the summer? Said what?
Disabled one.
Okay, so you're working where now?
At my mom.
Okay, so that is an update or change that needs to be made. So I think this said you were working, no, it says the garden center, Menards Garden Center. I don't know that here. Are you working you're part-time working?
Yeah,
Okay.
I'm trying to do it for full time.
Okay. What's your major?
I want to decide.
Court's going to adopt the recommendation with modification. It's gonna be 6 months probation. While on probation, you have the following conditions. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription, okay? You're going to be required to do random preliminary breath testing and or urinalysis testing. You'll pay the fees associated with that. Let's see, you're not to be at any bars or any nightclubs while on probation. You're gonna order that you complete an anger management group while on probation. You're gonna also complete 50 hours of community service. Give you 90 days to do the 50 hours of community service. And you can find out from probation the approved locations of the community service, okay? Gonna grant status under HYTA. You're not to engage in any assaultive or threatening behavior while on probation. You're also to maintain your employment and provide verification of that, okay? You have any questions about your probation status? There was no restitution.
Instruction.
$75 crime victim rights fee plus $50 state minimum cost that will be assessed. Is a $30 per month oversight fee for probation. I'm ordering you to do 6 months of probation, so that's $180. I'm gonna waive discretionary fines and costs due to your indigency status. It's a total of $305 that you'll be required to pay, and you'll make monthly payments on that, okay? Do you have any questions at this time about fines and costs or any of your conditions of probation? You'll go down to probation when you leave here to check in with them. Make sure they have accurate contact information for you. And then lastly, there's an advice of rights as to probation. It says you've been sentenced to a term of probation in the 54A District Court, and your probation conditions have been individually tailored and are specific to address your assessed risks and needs, except for charges or convictions of domestic violence, criminal sex crime, stalking offenses, or offenses where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge from probation. So you would have the right to request early discharge from probation once you complete half of the original term ordered by the court. So in this case, 90 days in, okay? And in order to do so, you would have to be compliant, meaning you did not violate within those 90 days, okay? And then also, you would have had to do what I told you to do, which is to complete anger management, and you were working and you provided evidence, and you did your 50 hours of community service, okay? So if you do all those things in 90 days, you can be done with probation in 90 days, okay? In order to request early discharge from probation, either your probation officer can make that request, provide a copy of that request to the prosecutor, and they can request or make it a written objection, or you can make your own request, okay? You would use the court's MC 512 form that's on the court website, or you can get it from your probation officer. You would serve a copy of your request for early discharge on the probation department and on the prosecutor's office, okay? If they want to, they have 14 days to respond in writing if they want to object. If I set it for a hearing, you do have the right to be represented by an attorney, but you would have to hire an attorney. You don't have the right to court-appointed counsel for a hearing on early discharge from probation, okay? Do you have any questions about that? Any additional matters for the record?
Nothing for the people. No, Your Honor, thank you.
Thank you. Good luck to you, ma'am. Good luck. Okay, Mr. Etheridge.
Yes, Your Honor.
That's both is fine. Let's see. Let's see. Okay, on the record in the matter of the people of the state of Michigan versus Frederick Edmund, file number 21-03462, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Attorney Derek S. also the public defender on behalf of Mr. Edmund. I'm appearing by Zoom from the courthouse. Mr. Edmund is appearing by Zoom from another location.
Okay, today was the date set for Mr. Edmund to have a probable cause conference. The matter is scheduled for preliminary examination at 8:30 May 3rd. Are we continuing to exam?
At this point, Your Honor, we're asking the court to leave the matter on for exam. There were a couple of issues with discovery that I've addressed with the prosecutor. She is going to attempt to get that information for us by next week. Mr. Edmund this morning advised me he's also trying to get something from the U-Haul place. Hopefully we'll have all this information by next week. If not, we'll let the prosecutor and the court know.
Oh, very good. I'll note that here on the file. Do we have any other issues we should address today on the record?
Nothing from the people.
Nothing further from the defense, Your Honor.
Okay, you're all set, Mr. Edmund.
Okay, thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Isaac Richardson, file number 24-01100, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Attorney Derek Etchers, also the public defender on behalf of Mr. Richardson. I'm appearing by Zoom from the courthouse. Mr. Richardson is appearing by Zoom from another location.
Okay, today's the date and time that was scheduled for a probable cause conference. The matter is scheduled for preliminary examination on May 3rd at 8:30 in the morning in person at the court. Are we continuing on that matter?
Yes, Your Honor, we're asking the court to leave the matter on for preliminary examination at this time. There has been a preliminary plea offer of pleading to both counts with HYTA and no upfront jail. I countered that offer and asked the prosecutor to consider pleading or dismissing one count, and he would plead to one count with YTA and no upfront jail. It's my understanding she is going to try to get approval for that. But at this time, while that negotiation goes on, would as a matter be left on for next week, and it's likely that it will just be a waiver next week. Thank you, Your Honor.
Oh, so any additional matters for the record?
Nothing from the people.
Nothing from the defense, Your Honor. Thank you.
Okay, you're all set, Mr. Richardson.
Thank you, Your Honor.
Appreciate you.
Thank you, Mr. Richardson. I'll be in contact.
All right.
Matthew Ream. Sorry, what'd you say? Matthew Ream, is he in custody still? He's not.
Yes, Judge.
Oh, okay. Are we having a hearing on that?
Right, for the, I think it's just gonna be a sentencing.
Oh, gosh, okay, sounds good.
Yeah.
Okay, let's see. On the record in the matter of the people of the state of Michigan versus Sandra Baxter, file number is 24-00482.
They're in the breakout room.
Oh, are they? Sandra Baxter's right here, though. There you go. Gino Devontae Garcia, is he present?
Your Honor, I have not been able to get in contact with Mr. Garcia.
Who's on the, Solera? Can you unmute, please?
Yes,
What's your name?
Gina Garcia.
There's that. You need to meet with him?
Yes.
Okay, hang tight. Your attorney needs to meet with you. Mr. Arkaniki?
Yes, Your Honor.
Okay. Okay, I see you are present on the Logan Capital and then Sammy McCoy. Let's see, Mr. Moore is here for Sammy McCoy, is that correct?
Yes, and Mr. McCoy is also here.
Okay, sounds good. On the record, in the matter of Logan Capital versus Sammy McCoy, file number is 23-03115 LT. Appearance, please.
Good morning, Your Honor. Robert Akinicki, attorney for the plaintiff.
May it please the court, Your Honor, Andrew J. Moore on behalf of the defendant, counter plaintiff, Sammy McCoy.
Okay, sounds good. So today was the date that was scheduled for a bench trial. My understanding is that we are not going to continue with trial. There has been a conditional dismissal agreed upon. Is that accurate?
That's correct, Your Honor. I believe Mr. Moore prepared that. I had given him permission to sign. The terms essentially are that Mr. McCoy is going to vacate and have his security deposit returned. I can let Mr. Moore place any additional terms on the record that he wishes.
Yes, Your Honor. A conditional dismissal was filed electronically yesterday. You should have a copy of it. I'm not sure if it actually was processed, but client's going to vacate by 5 p.m., return the keys, remove all personal property, and plaintiff's going to return the security deposit of $2,000 within 3 days after the keys are returned.
He's going to vacate by 5 p.m. today?
5 p.m. Friday, May 3rd.
Security deposit of $2,000 is going to be returned within 3 days.
As long as he's out.
Okay, Mr. McCoy, is that accurate as to how you want to proceed?
Yes, that was the offer I received. It is going to be some work. I have 15,000 square foot of inventory to move out within the week, but I'm just gonna have to work overtime and try my best.
Okay, so you understand, sir, that you have the following rights that you would need to give up in order to move forward with the conditional dismissal. So in order to have this case dismissed upon the condition that you will vacate the property by 5 p.m. May 3rd and have your security deposit returned to you within 3 days, you would have to give up your right to a trial. And you were scheduled for a bench trial today, but you also have the right to have a jury trial had you demanded a jury trial. You understand that?
Yes, I do.
You willing to give up your right to trial to have a conditional dismissal?
Yes, Your Honor.
You also have filed a counter suit against the plaintiff, is that correct?
I did.
And you're willing to dismiss that in order to move forward with the conditional dismissal?
Yes, Your Honor.
Anybody threatening you to get you to give up those rights or your counter suit?
No,
Any promises being made to you if you enter into this conditional dismissal?
no, Your Honor.
And so you need to have the property completely vacant, turn over those keys. If you intend to do an inspection, I'm sure your attorney probably advised you that you should, or a walkthrough, that you do that no later than 5 p.m. May 3rd. Otherwise, the plaintiff has the right to have judgment entered against you immediately without giving you notice of a hearing. Do you understand that?
Yes,
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights you've given up, you can return to the court. You can request to have this agreement set aside, and then we'll set your matter for a hearing, okay?
yes,
Do you have any questions for the court?
I do not.
Any additional matters for the record, counsel?
None for me, Your Honor.
Nothing from me, Your Honor.
You're all set. Thank you.
Thank you.
And then we can bring up a room. on the record in the matter of the people of the state of Michigan versus Matthew Heath Green, file number 24-00295. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people. Aaron Robinson, Assistant Public Defender for Mr. Reed.
Okay, how are you, Mr. Reed?
I'm doing great.
Very good. Today was the date that was scheduled for a sentencing. It looks like there was a bond violation hearing scheduled for today. We have another matter pending.
Yes, Judge, that was recently bound over to the circuit court.
Oh, okay, it was a felonious assault bound over. Okay. If you have a pre-sentence report dated prepared April 19th, you got a copy of that, counsel?
I do. Yes, Your Honor.
You need to make updates, corrections, or deletions.
That's from the defense.
And just a small one, in the PSI, it states that his pending case of a resisting and obstructing police officer is bound over. That case, I believe it's actually 2 counts of police officer resisting and obstructing, and then also an ethnic intimidation charge was added at prelim. So just to make sure that's accurate.
And file number 24-0633.
That's correct.
It's 2 counts of what?
A police officer resisting, obstructing, or assaulting, resisting, obstructing, and then a charge of ethnic intimidation.
That will be noted. Any additional changes?
No, Your Honor.
Make allocution, counsel.
Yes, Your Honor. We would be asking the court to sentence Mr. Reed for a period of time served. From my calculations, it looks like he's been in close to 90 days. He is currently sitting in on another felony case that has been recently bound over to the 30th Circuit Court, in which we are working on getting him into possibly a treatment program and working out some sort of treatment option up there in Circuit Court. So we would ask for a term of time served here with the understanding that it's likely once his other case is set for a pretrial up in Circuit Court, that a resolution involving some sort of treatment will likely happen up there.
Okay. Did your client want to make a statement?
I think I'm just grateful that things are working out the way they're.
Yes, the people just requested the court follow the recommendation from the PSI for the 180 days in Ingham County Jail with credit for 75 days. I understand that he has been in custody for those 75 days. However, given his conduct in picking up new cases and picking up the same type of cases that with the same type of conduct that happened in this case, I feel that the 180 days would be appropriate.
Judge, if I could be in.
You can.
So my concern is that with the 180 days is that I just don't want that to affect his ability to get into a treatment program, because I do think that that is what Mr. Reed needs. That's what he wants. He's stated to me numerous times about how he wants to get treatment, how he wants to work on his issues with drugs and alcohol, which precipitated this whole case. And so I want to make sure that we can do that for him.
Let's see.
Next week.
You can.
Right now I'm attending classes, so I'm in breakout class, I'm in Seek and Safety, and I'm in Kingdom Man, I'm doing Bible study, I'm trying to get closer to God, who I believe in, I always have. And also, I'm just trying to better myself. This has really been beneficial for me. It's the first time I've ever been in jail, and it's like working out for me. I'm seeing a positive outcome of this. And I do want to go to this treatment. I really do want this treatment.
I think that you would benefit from some treatment. This is your criminal history. Y'all think this is? See how thick this is?
Oh, yeah,
This is your criminal history. Do you know how much time it would take me to read through all of this?
I know. I've been in and out, in and out, in and out.
Yeah,
And I've tried to get mental health help before, but it seems like they always just shut the door in my face. This time they're saying they're gonna help me with that I can get mental health counseling and drug treatment classes and everything. I'm already doing drug treatment and you're not cognitive behavior classes.
I can appreciate that you are having a change in some of your behavior patterns, but these changes don't appear to have come about until recently. I mean, you got new cases pending. You have a bond violation before me right now.
Yeah, I didn't.
Which I don't need you to speak anymore. You're all set now. You have a bond violation as indicated by the prosecutors. The charges are pending that are assaultive in nature. And again, felonious assault is what's pending and being bound over, I believe.
No, the felonious assault was this case, Judge. I'm sorry.
I'm sorry, 2 counts of police officer assault resisting and obstructing, plus an additional count of ethnic intimidation. But again, this behavior or a pattern of behavior that has been consistent with what I saw in your criminal history report, which again is too many pages for me to spend time counting. So I do think you need to get some treatment, but you're gonna get the treatment after you complete my sentence. The sentence will be in proportion with the recommendation. The recommendation is for 180 days Ingham County Jail with credit for time served. The court will refer fines and cost of collection. I'll adopt that. That'll be your sentence. You'll be remanded to serve 180 days. Ingham County Jail will give you credit for 75 days.
I believe he would be entitled to 83 days now, because I think that the report was prepared on the 17th.
Eligible, 83, not entitled. But nonetheless, we'll give you 83 days credit time served. No earned early release, in addition to that. So I don't want any letters from the jail that you are working as a porter, and so you think you can get good time for that. You're not getting earned release, okay? I will dismiss the bond violation hearing as that matter is pending, and connected to a pending matter in the circuit court. Do you have any questions about your bond? I mean, about your sentence? No. Any additional matters for the record?
Nothing from the people.
No, Your Honor, thank you.
You're all set. Okay, let's see. Oh, we need to bring someone else from jail around to Mr. Austin. I haven't seen Mr. Austin all day, actually. Hakeem Speed? That's for 1:30. Oh, okay, you're right.
The only thing left is just a PCC with Gina Garcia and Mr. Goodrich.
Yes, he's all set. No, okay, it looks like he is. On the record in the matter of the people of the state of Michigan versus Gino Devontae Garcia, file number 24-00948. Council appearance.
Trustee on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Garcia, who is also appearing over Zoom today.
Mr. Garcia, can you unmute your device, please? Mr. Garcia. Okay, it doesn't look like Mr. Garcia is responsive, so we'll move on. Maybe you can call him Mr. Goodrich.
Okay.
He's cleaning his nails with his mail. On the record in the matter of the people of the state of Michigan versus Sandra Baxter, file number 24-00482 FY, council appearance.
Good morning, Your Honor. Steen Grant, P51260, Assistant Attorney General on behalf of the people.
Morning, Your Honor. Pat Prabhu, P86987. On behalf of Ms. Sandra Baxter, we are both appearing via Zoom.
Okay, today's the date and the time that was set for a probable cause conference. This matter is scheduled for preliminary examination in person at the court, May 3rd, 9:30 in the morning. Let's see. Are we continuing to exam next week?
Well, Your Honor, Ms. Green and I, we were in a breakout room earlier, and this case is pretty intensive in the discovery. I believe we received about 75,000 emails to sort through. And she has no issue, to my understanding, with us extending it out a little bit. Ms. Baxter is also preparing to waive her 21 days. And after Ms. Green and I spoke, we were hoping that we could shoot for June 6th. It seems to match up for our schedules the best. Check the court schedule. It didn't look too backed up, but that's obviously not my decision.
I'm not available. I'm not available on June 6th.
Not available on June 6th.
We'll give you a date that will be available.
Okay.
But the people have no objection to adjourning the exam off next Friday because there's 74,000 emails alone.
Okay, Ms. Baxter, you understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned?
I do.
Okay, you're willing to waive your timeline because of the extensive amount of discovery that your attorney needs to review and hopes to help formulate your defense. Okay, anybody threatening you to waive that timeline?
I'm sorry?
Anybody threatening you to get you to waive your 21-day timeline?
No, not at all.
July 11th at 8:30.
I have no objection to that, Your Honor.
Could I have an additional week? I'm doing an all-day preliminary examination in front of Your Honor and Ms. Lombardini on the 12th. And that's going to take a lot more prep work. Could I have like the following Monday or Tuesday? Is that possible?
Yeah. Somebody schedule something on the 12th. You probably will go. July 12th. Yeah, July 12th, no.
The July 12th, I have Heather Lombardini scheduled in front of Your Honor.
Okay, we may have to, we're probably gonna have to reset the Lombardini because I don't think we were advised that it'll be an all-day exam, so we have other matters scheduled on that date.
Okay, well, if Lombardini is going to be moved, then the 11th works.
Okay, we will move forward with July 11th on this one, and then we will notify you and counsel on the Lamborghini matter on new dates via email, okay?
That's fine with me. Thank you, Your Honor.
Thank you, Your Honor.
No problem. No problem. Any additional matters on today's record for Ms. Baxter?
Nothing for me, Your Honor.
Nothing. Thank you.
Thank you. You're all set.
I know.
I think you requested. Okay, that makes sense. Okay, we'll reset that other one later. Mr. Goodrich, were you able to get in contact with your client?
Your Honor, I did just type in the chat, Mr. Garcia has turned off his mute, and I believe he is ready to proceed at this time.
Mr. Garcia, can you hear us?
Yeah, I can.
Okay, on the record in the matter of the people of the state of Michigan versus Gino Garcia, 24-00948. Appearance for the record, counsel.
Assistant Prosecutor Peter Petrosky on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Garcia.
Okay, Mr. Garcia, today is the date that is scheduled for a probable cause conference. The matter is scheduled for pretrial May 3rd, 9:30 in the morning. Are we continuing to examine?
Yes, we are, Your Honor.
Okay, let's see. It will be in person at the court next week, May 3rd, 9:30 in the morning. Any additional matters for the record?
Nothing from the people.
No, Your Honor. Thank you.
Thank you. You're all set, sir.
Okay.
Thank you, Mr. Goodrich.
Okay, thank you.